We're going to go right into our first panel and discuss the legal issues and next steps. First, I want to briefly apologize on behalf of one of our panelists who unfortunately was not able to make it. Henry Ben-Certo, who many of you know is the Consul General for the Philippines in San Francisco, was actually in D.C. last night, and he was ready to join us this morning, but unfortunately, his government recalled him, and he was on the plane back to the Philippines today, and so we're a bit disappointed. But we do have a terrific panel, and so let me very briefly introduce everybody who is with us. To my right is Julia Xue, who is an Academy Senior Fellow at Chatham House this year in the International Law Program, and her permanent position is at Shanghai Jiao Tong University, where she is a professor of international law and director of the Center for Rule of Ocean Law and Studies. To my left is Dr. James Kraske, who is a professor of oceans law and policy at the Stockton Center for the Study of International Law at U.S. Naval College in Newport. And the other to my left is Professor Eric Franks, who is a member of the Permanent Court of Arbitration and president of the Department of International and European Law. You're going to have to help me with the pronunciation of the university. Okay, Verdet University, and Brussels, Belgium. And standing in a bit just to join the panel is my colleague, Greg Poling, who is not going to give a presentation, but will simply join in the Q&A discussion. So without further ado, we're going to turn to our panelists. They will speak for approximately maybe 5 to 7 or 8 minutes, and then we're going to open up the floor to discussion. So we'll turn to you first.
Thank you very much, Bonnie, and good morning, everyone. It's such a great honor to be invited by CSIS for this very important event, and probably a historical one. As we all probably know, there is a very fresh award came up this morning. And so I prepared something for the topic assigned for me, like what China claimed in the South China Sea and how China interpret the law of the sea convention. But I think I really can't really talk about that. Basically, according to the award, particularly in the Spratly area, and what China claims basically prejudice. So a lot of things have changed. I'm kind of in a very disordered kind of status. So I just put up something together and then probably share with you my views at the first instance, very temporary or preliminary view. I think with this award, we should congratulate the Philippines, my colleagues in Philippines, over years of hard work, and they really got a big win. But we are yet to know what kind of consequences, the legal risks or consequences follow on with this thing. It is so fresh now, we're really not adjusted to this. But basically, I think by the award, all the Filipino claims are supported, basically. If you look at the 15 ones by the award on the administration, jurisdiction and I can't remember the word, admissibility, and then half of that was the tribunal announced it had jurisdiction, but now we see basically only 15, the 15 one, and the 14 get ABC, not claim, the tribunal claim it doesn't have jurisdiction. Other than that, all of the claims are basically supported. And I think China really facing a kind of destiny probably being squeezed out, if not the whole South China Sea, but certainly probably the Spratly Islands, the area. And then this is quite substantial, I think, for the Chinese government to take it, as we see from Senator Sullivan, but is it a challenge or it's a kind of opportunity? I think this is related with this question for myself personally as an independent scholar. I mentioned, Bonnie introduced me, I'm with Chatham House for a research project on China and international law. And for my observation, and we had a lot of discussion about the kind of the potential award, but we really believe the U-shaped line, or the 9-dash line, should not be touched upon because this is something quite complex or complicated. And China really hasn't at least clarified what its legal status. And it come along such a long history. And the genesis of that one, I think at least the latest start in the 1940s. And then the UNCLOS came along only in 1980s, or it started from negotiation only in 1970s. And this is one of the issues. Another probably the Taiping Island, the Ituaba. Those are I think, at least for these two, we didn't really expect the jurisdiction and in this manner, in this nature. So I think based on that, maybe I could talk a little bit about China's sovereignty there and relate to the assigned topic. I think for this probably very important part, and a lot of things probably not neglected maybe. I think for the South China Sea claim on the China's part is not as deemed everything within the U-shaped line. I think we should differentiate that. Maybe the sovereignty relate to the land features and then the waters. Probably the waters part is more problematic because China really doesn't make it clear. And then also relate to its activities like at sea enforcement and things like that. But with that, now I think we have to face a new situation about spread list because spread list now basically shared or disputed by several parties there. And then how the other parties will adjust with this situation. So I think this is a position probably not only challenge China, also challenge international law. As I mentioned about the who comes first and who has that. And we probably will be aware of a series of the national practice and historical records and also declarations. After the post-World War II, a lot of legal documents are there. And how do we interpret those things? And also about China's own national legislation mentioning the sovereignty over the separated islands, called Nansha Islands, and things like that. I think there is brand new kind of feeling we need to really to get back, even though for scholars, it's quite challenging for the further on kind of research, how to adjust our own position. I think this is one of the issue, and I think this is, I really believe the award is quite aggressive in this respect, because I think international law really respects sovereign state and the sovereignty. And then with China, particularly China, very sensitive about sovereignty and security issues. So I think with these two issues touched upon, and probably we can see, we probably won't be surprised to see some renewed kind of effort for China to consolidate its claims in area. And also, I think I want to emphasize for the Law of the Sea Convention itself, if you look at Part 15, and really respect the bilateral negotiation, or even not bilateral, but the free choice of states. And so that's why I think they really respect, if you look at the limitation or exception within the 3 sections in Part 5, you can see that. And with the Taiping Island, I think not only probably China affected, but other states like the Vietnam, the features controlled by Vietnam, by Philippines, by Malaysia, and if Taiping Island is not island, and what else? And that is the largest one, we all know the fact, and have been stationed for so many years by the Chinese Taipei there. So I think this is probably also a China's choice. And for Taiwan, too, and how to deal with this issue. And overall, I think if you relate to a little bit back to the assigned topic for myself, how China interprets the international law, or the Law of the Sea Convention. And its general kind of feeling, or impression at least, for my observation, and China had been expected to behave in a certain way, and interpret the Law of the Sea to a certain extent in a certain expected way. And that's a general thing. If China doesn't do this way, and China, like even with the position China take with the arbitration, and like mount to the not respect of international law, and things like that. So I think for China itself, at least, this is a great failure for China. It can't really convince the international community about its stories. And I think there are so many reasons about that, but very obviously China, like Joseph Nye commented, and China doesn't have the soft power or even a smart power, and to really to secure its convince its views or its claims, and also given the change, the legal context in the South China, by the law of the sea, extended maritime zones, and China really faced not many options, and probably that's the position China take, to refuse to participate or accept, and also not to be bound by this award. And that's really a hardline position, but we can see the policy kind of deliberations there. And I think if we can recall a little bit about the compulsory kind of arbitration, that can only be sought after other procedures have been exhausted, and China have different views on this. And look at the arbitration case, and I think this bypassed kind of really believe that bypassed bilateral negotiation process, and China have previously been engaged in to resolve this dispute. And also about the consent of parties, I think that's another issue, and China have different views. And I look at paragraph 1200 of the award and said it's the fundamental principle of international law that bad faith is not presumed. But I think what about China had different views, and with the U-shaped line claim, the claim in the South China Sea, or the U-shaped line status and things like that, and also China's effort to be within international legal system. So should China get out of this to become outlaws, or really push China outside of South China Sea, and things like that? If you look at what's next, or why China should be bound by this award, I think two reasons probably for state to comply with judgment or award or decision of the international court or tribunals, and one probably for the reputation, and also the influence of this kind of decisions or judgment, but also the other probably for the advantage of the country itself and others. But for this case, probably for China, it only see to the advantage of others, but not itself. So it's really, that's why the position for China. And then I think with this kind of result, and China certainly suffered reputation damages, that's for sure, since the initiation of this arbitration. But I guess China can weather this kind of impact, because there were we see this precedents by Russia, by US, and then probably afterwards China can adjust itself. And the law of sea system has no mechanism for China to imposing sanctions for China not to abide by this ruling. And China certainly will not face any immediate and tangible punishment for its non-compliance. I think that's the thing really worries international law scholars. And China certainly will suffer damages to its reputation, but I think, yeah, China can adjust as a big country or rising power, but because really this issue touched upon its nerve about sovereignty. And it's also when we talk about military things, and that is related very strongly about its security, maritime security. And I think the award probably, to my observation, at very temporary, I think very aggressive outcome, probably really will be the case for many years. I won't see that probably, but we don't see many of things, a similar kind of award like that. And also the case itself has more political than legal significance. And for Philippines, I think if we keep on going this way, probably we reach a dead end. And so I think, as previous keynote speaker mentioned, probably it's really, if we take it as a good start, and not to force China to accept arbitration, but start with negotiation and then compromise in the area, and that probably, and for the I think for the U.S. really trying to force China to abide by or reinforce international law, probably this will push China further off. So this is just my preliminary observations. I think with that, I really wish the South China Sea and the region all the best. Thank you very much.
Well, thank you, Julia. You're very much in the hot seat today, so I really appreciate your joining us, and I'm sure that there will be many questions that will be posed to you as well as the other panelists after we finish the introductory remarks, and I'm going to ask James Kraske now to give his presentation.
Thank you kindly, Bonnie and Julia. Well, I'm glad to say that, as I predicted in my piece with the Maritime Awareness Project, that none of the features in the South China Sea, including Ituaba, were afforded a prospective exclusive economic zone or extended continental shelf. This is not necessarily because I have a special insight or prescience, but simply because I applied the law to the facts and reached a legal determination. And it seems that there's a great deal of shock that the tribunal did exactly the same thing. It's important to remember that the gentlemen on the tribunal are legal technicians. They're not IR specialists. They don't deal in Hans Morgenthau and power politics. They apply the law to the facts and they reach a legal outcome. And I think that the only thing that I'm shocked at is that, or pleasantly surprised, is that the system worked, the process worked, and that they were apparently not influenced by political factors. So the status of the features has now been decided. That was the first major thing that was decided. The second thing that was decided was very much a surprise to me, and that was that the tribunal did take on and invalidated the entire 9-line claim, which frankly I did not think that they would have the gumption to do so. And moreover, to put a fine point on it, the tribunal said that the law of the Sea Convention comprehensively allocates rights in the maritime domain. And again, this is purely application of international law. The first thing that students in law school learn is that the later in time prevails. If you have a 1947 law and a 2009 law, the 2009 law prevails over the 1947 law. It's the same in criminal law, civil law, and international law. So this, again, should actually be no surprise, the only surprise being that the tribunal was able to distance itself from political pressure in throughout the couple of years. Also, the tribunal said that protection for pre-existing rights were considered during the third UN Conference on the Law of the Sea Convention. And this is another important reminder of a staple of international legal analysis, which is that when the intentions of the parties are not clear, you look to the travaux préparatoire or the preparatory materials and the debates in the third UN Conference. Those are freely available on the internet. All 17 volumes, and they're PDFs. You can do word searches for all of your favorite activities. If whales are your things or intelligence activities are your thing, you can see exactly what was discussed and what issues were raised, including military activities in the exclusive economic zone. The idea was rejected. Coastal state authority to control military activities in the contiguous zone were rejected, as well as this idea of historic or pre-existing rights. Some coastal states advocated for that position, and those positions were not adopted by the conference, and therefore that's the intention of the parties. So to the extent that China had historic rights, they were extinguished by the Law of the Sea Convention, and that should not be a surprise if you simply apply the facts to the law. Finally, it was heartening, I think, to see that with regard to the third major set of issues, which is that the tribunal rejected some of China's more egregious maritime activities in the South China Sea. Again, more because the tribunal had the forthrightness to do so rather than any kind of clever legal insights. And this is just a straight application of Law of the Sea, Article 92 and 94, flag state responsibilities. We talk about, a lot of times at the IMO, we talk about flag state responsibilities in terms of open registries or flags of convenience. What about flag state responsibilities for the conduct of your fishing vessels or your Coast Guard vessels in compliance with the collision regulations, Rules 6, 7, and 8, that the tribunal accepted? What about flag state responsibilities for protection of the marine environment, Articles 192 and 194? All of these things are in the convention, and so it was simply just an application of the law to the facts. Finally, it was interesting, the fourth sort of set of issues that were discussed by the tribunal is the aggravation of the disputes. And anybody familiar with civil procedure and civil courts would recognize the same thing. That is, that tampering with the evidence, attempting to influence the tribunal, all of these things are outside of the legal process and are certainly frowned upon. So in conclusion, what I would say is that that the decision underscores the importance of international law and the rule of law, that law matters. Law is not simply a political tool. The rule of law is different from the rule by law. The rule of law is when the law binds the strong as well as the weak, and the rule by law is when the powerful use the law as a tool to control the weak. And I think that this is an education or a reminder, not just for China, but for everybody, and especially for those students in law school, which is that law school is not an Oprah Winfrey show. It's not, I think, I feel, in my opinion, but that actually there are certain rules and standards that apply to facts, and you can fairly easily reach a legal determination. There are some hard cases, but for the most part, the things that are in this decision are not hard cases. It's only that that politics did not intervene to further confuse or disrupt the process. Finally, I would conclude with that this is a particularly bright spot, in my view, for the United States, because what it demonstrates is the wisdom of the United States as really the principal force behind seeking a mandatory dispute resolution process in the Law of the Sea Convention when the U.S. negotiated it. And it underscores the importance of the United States joining the Law of the Sea Convention. This tribunal was eminently responsible in completely avoiding military activities and in applying the law in a fair, straightforward, forthright manner that the United States should respect. So I would conclude with saying that, particularly for Senator Sullivan, that this is another indication or another aspect of the Law of the Sea Convention being wholly within the United States' interest. Thank you.
Thank you. Very crisp, clear, and concise. And now we're going to turn to our third speaker, Eric Franks.
Thank you very much. First of all, I would like to thank the organizers of this conference for having invited me. But what a timing. I mean, this is brilliant, no?
It's a coincidence.
It's a coincidence, but still, it puts a lot of pressure on this first panel, which, of course, needed to get up very early in the morning. And this, I think it's about the first time that I profit from jet lag, because I woke up at 5 o'clock anyway this morning. So better use the time usefully and start reading. But at the same time, I must say that I did not read through the 497 pages, right? I only read through the abstract, which the PCA has been so useful in providing for us. So this is a first assessment. Now, besides that, of course, when we were first approached to speak at this conference, we all had specific topics attached to us. And so I did submit a paper yesterday with the things that I was asked to write about. So what I would like to do today is simply to say a few things on that paper, and secondly then have a first assessment of what I think are the most useful points which were made by the arbitration, and all that, I hope, in 8 minutes or something like that. All right, let's start with the paper that I had to write. And the paper was about the dispute settlement provisions of the 1982 convention. And I prepared a slide. I don't know whether it's possible to put it up. Not really?
Hopefully it will magically appear.
Yeah, who knows. Anyway, what we did was we looked at the system as it was initiated by the Law of the Sea Convention. And I must say that one of the architects of the whole system was Professor Louis B. Sohn, who was my mentor when I was able to study under his guidance at the University of Georgia some time ago. He devised the whole system, and it's a very, I would say, progressive system, especially if you compare it to other multilateral international conventions which existed up till then. If you look at the 1958 system on the law of the sea, there were 4 conventions and there was an optional protocol. Now, the word optional already mentions that it's something at the periphery. The only convention of those 4 which did have some dispute settlement provisions, and that was the one on fisheries, that was also the convention which had the least number of adherents. It has been labeled as a failed convention, so it means that this was really not within the system as it existed before. The 1982 convention, for the first time, was able to put it at the center of the whole convention. Why? Simply because it was a package deal. States could not tamper with individual provisions by either making reservations or having personal interpretations which were then not being able to be challenged. Secondly, the issue is also that a special tribunal has been created, and it might be strange that this arbitration is a so-called Annex 7 arbitration, because if you established a new body, which is the International Tribunal on the Law of the Sea, which is located in Germany, and you establish that body, and apparently it has not yet been of the same importance, I would say, with the development of the law of the sea as these Annex 7 arbitrations. And this very much had to do with the inventiveness of Professor Louis Sohn, because as he went along and tried to find a body which would be acceptable to everybody, it proved that this was impossible to find. So what he did was, everybody could make a choice out of 4 issues or 4 different bodies, and if parties would not be in agreement on the body, then arbitration according to Annex 7 would be obligatory. This now has proven right, because if you look at the number of arbitrations, and the slide would certainly illustrate that, if you would look at these different kind of arbitrations, we have had more arbitrations on substantive matters than the International Tribunal on the Law of the Sea has yet decided on also substantive matters. Another point that I would like to stress today is that in the press you often read that this is a decision of the Permanent Court of Arbitration. Nothing is less right than this statement, right? This is not a decision of the Permanent Court of Arbitration, which unfortunately is also located in The Hague, and of course today the decision was made in The Hague, but this arbitration is an Annex 7 arbitration. It's very important because the basis, the legal basis, is not the conventions of 1899 or 1907 on which the Permanent Court of Arbitration is based, but it is on the Law of the Sea Convention. So it means that all the states which are party to this treaty automatically accept Part 15, which is obligatory dispute settlement. A last point that I would like to make is non-appearance. This is something which has recently appeared, and for this, the decision of today is a marker, because it's the first final decision where a state has not appeared within our Annex 7 arbitrations. There is another one in which we had the privilege of being involved, and that is the Netherlands-Russia arbitration, but that, even though there has been a decision on the merits, this has not yet been finalized because the quantum of the compensation still needs to be decided. But it illustrates that apparently these Annex 7 arbitrations, which today become more and more normal, I would say, is something that states maybe did not know the exact importance when they ratified the treaty. It's only now that more and more of these arbitrations come to the fore, and that we see that states like Russia, like China, apparently start to realize that maybe this is not the way that they intended the thing to go. If I can then turn to the elements that I find most interesting. Oh, and the slide is there, but it's so small that you can't read. I hope you will receive a print where you can certainly make sure that everything I said, it's true. The only point what I still wanted to make about this slide is that if you look at the link between these arbitration and Annex 7 arbitrations and the Permanent Court, the only link that exists is the registrar. The only thing that these arbitrations make use of the Permanent Court of Arbitration is the registrar. And we all valued this morning, because they said that this decision would be published at that time on that website, and it was there for everybody to read. So it means this is all that the registrar is responsible for. It means to make sure that all the contacts between the parties and the judge and the arbitrators, and also the way in which the arbitration then is being run, goes smoothly. And I must say that they have done a very, very good job at that. So what are my points? What do I remember from this arbitration? I was one of the skeptics in the sense that I was of the opinion that the first hurdle was the most difficult one, and that was the jurisdiction. And here we see that the arbitration that has already been mentioned today has been giving the green light all the way, except for a very few elements on the Article 298, that is the optional exceptions, where China said that military activities were not allowed, that they would not accept jurisdiction. And here the court stated that since this ship, which was posted on one of these islands, that the Philippines had run aground there, and the tension around the ship was military activities, the court said we will not be able to deal with that. But that is the only exception. What is also important, I think, is that the court clearly stated that making use of Part 15 is not an abuse of rights. I mean, if you talk to people from Southeast Asia, they always tell you, well, but in our region we do have a system where we don't go to court to settle disputes. Well, this might be true, but in the system of the 1982 Convention, everybody accepted something different. And so going to court is not an offense to the other party involved. With respect to the merits then, I think the important points are, and here I disagree a little bit with my colleague to the right, law is not always something which you simply have to apply, especially Article 121, paragraph 3. This has been a major bone of contention in international law. If you read the provision, if you go back to the travaux préparatoires, you will understand that this is not something that you can simply apply by reading what is stated. If you go to the travaux préparatoires, it's a mix coming from all different sites which was then put together and which does not make a logical whole. So you cannot, by simply applying it, literally try to come to a conclusion. Courts and tribunals, up till this very day, had been very reluctant to touch upon it, and they always had been able to hide behind the screen of delimitation, not to have to tackle the issue of whether something is a rock, according to paragraph 3, or a rock which is not one, according to paragraph 3, or an island, meaning that you have all the maritime zones involved. This tribunal, for the first time, has had, I would say, the guts to deal with this issue. And this by itself, I think, is worth stressing. And with that, I would like to conclude my remarks. Thank you.
That was excellent. So before we turn to the audience, I'm going to ask our panelists a brief question. And I'm going to start with the two gentlemen to my left on this question of Article 121.3. And I'd like you to comment on whether you think that, given the definition, and I understand, of course, you have not read the full almost 500 pages, and I'm sure there's more there on this question, but based on what you have read so far, do you think that Woody Island in the Paracels is an island? Is it entitled to an EEZ? And what about the Senkakus that Japan administers in the East China Sea?
If I can give my first impression on this question, I think that the methodology of the tribunal in this case has been very clear. They attached a great deal of importance to the past, how the issues or how the islands were at the time that in their original state. And so it means if you go back to the same thing as what they did with respect to Ituaba, if you go back to what Woody Island was in the beginning, you will come to a quite similar kind of conclusion. This is, I think, very important to stress, because otherwise it's impossible to know whether something is a rock or an island. And the tribunal has done that not by going over one-night ice. I mean, they themselves, and this is also very exceptional, ordered people to check the archives of particular countries in order to find out what the status of these islands were before. This is very unheard of, because, of course, there was nobody there to do the research for them. China did not express itself, so they had to do that by themselves. And this is at least also one of the points which need to be highlighted, is that the tribunal tried to at least have an informed judgment on what was the original status of these different features.
Thank you kindly, Bonnie. So the tribunal said that there's a four-part test. That is that there's an objective capacity of a feature in its natural condition to sustain either a stable community of people or economic activity not related to resource extraction or dependent on outside resources. And I agree that this is the first time that it's been succinctly placed and the line has been drawn very narrowly in this regard. But there is a certain amount of sort of embellishment of what constitutes an island that can sustain human habitation by a number of coastal states throughout the world, Japan and the United States being two of them, as a matter of fact. And so I think that by a rather narrow definition, a fairly strict application of what constitutes something that can sustain human habitation or an economic life of its own, the tribunal has gone a long way towards stabilizing the law of the Sea Convention by reducing conflict and helping states to avoid the temptation that they're somehow going to get a bonanza of resources out of a speck of, out of Gilligan's Island located in the middle of nowhere. Thank you.
All right, a brief question for you, Julia. In your presentation, I think you implied that China might have an interest in withdrawing from UNCLOS. And if I understand correctly, there are some benefits that China has, as do all state parties of UNCLOS, protecting its EEZ. China claims a continental shelf in the East China Sea, so that would also be protected. There's also protection for companies potentially engaging in seabed mining that state parties have, which those that are not signatories to UNCLOS do not have. So I wonder, just in your personal view, if you look on balance at the potential costs, reputational as well as these other things I've mentioned, and the benefits, how do you come out? What is in China's best interest?
Actually, I got some phone calls from some media in this morning where I read this 500-page thing in the morning. I think this is the question they asked, because this is something quite hotly debated at home since the Philippines instituted this arbitration. And for a lot of scholars, and they think this is the law really against China and probably start from South China Sea. And the only option for China is to denounce the law of sea convention. But I don't think this really reached to the kind of really the state level for the government to consider. As you correctly mentioned, I think my view is similar as yours. And you need to balance. And all in all, South China Sea only small portion of within China's national interest, or sovereign rights, maritime rights, and things like that. I think for the government, it's quite, the rationale behind that really need to balance the maritime rights, interests in other parts near the coastal waters, and also beyond that, including like the deep sea mining, as you mentioned, and other maritime activities. But I think, but this is certainly an issue, really make China feel like very, very limited space to manipulate maybe the domestic kind of height really about this nationalism maybe and some other things. And together with this award, I think that's why I'm quite concerned about that. Maybe something follow on with that, and the government really have to consider that kind of, I don't think it's a balanced or very rational kind of proposal, but we don't know. We don't know yet. It's too soon to judge on that. Thank you.
It is. I'm sure we're going to hear more reactions from the Chinese government in the future, and probably see some actions, not only hear rhetoric. We are now going to open up the floor for questions, and I'm going to ask you to please ask your questions briefly so that we can get in as many questions as possible. If your question is directed to a specific individual, please note that, and I'm going to collect a few questions at a time. And of course, identify yourself. So we'll start at this front table, this woman in the green. If somebody bring over a microphone. Thank you.
Hi, Jessica Stone with CCTV America. I think a lot of us are just wondering what your assessment is on what's next, the next consequences of this, and I would love for us to get a response from Julie. And then if somebody can sort of assess the Philippines' next move, since we don't have the Consulate General, and then I think we've kind of heard a U.S. what's next, but maybe an ASEAN what's next reaction as well, please. Thanks.
Okay, please hand that microphone to the woman next to you, Nadia Tao. Thank you.
Hi, Nadia Tao with the Liberty Times, Taiwan. My question is that before this tribunal result, I think most of the article we read is that Taiping Island will not be challenged. Itu Aba, as an island, won't be challenged. Does this result actually surprise you? And after this result, would you see a lot of litigation actually? Because you just mentioned Senkaku and other, island in dispute that other country may just follow suit. So what were your expectations? Thank you.
Okay, and please hand that to Mike McDevitt, and then we'll come back to our panel.
Hi, I'm Mike McDevitt. I have a question for for James, I guess, since he raised it. The knock-on effects of the 121 decision with regard to, as you mentioned, Japan and the United States. Just from the point of view of the United States, it seems to me Baker Island, Howland Island, Wake Island, and Midway Island have suddenly been stripped of their EEZs, I think, by this reading. Would you agree with that?
Sure, I'll just address the last one, the question. Thank you, Admiral. I think that they would have to be, those as well as Senkaku, Okinawa, Hiroshima, have to be looked at seriously, sure.
Greg, do you want to comment on the Philippines and ASEAN?
Sure, yeah. I'm certainly not a replacement for Henry Ben-Sorto, but I guess the closest thing we have to a Southeast Asianist on the panel. Well, if anybody saw the statement out of Foreign Secretary Yasai's office this morning, it's what we already knew we were going to get, which was Manila has to look more closely at the ruling before making any public statement. We already knew that was going to be the case. There's an awful lot of heartburn here in town about whether or not the Duterte administration, and Yasai in particular, might basically leave the international community holding the bag here. We've seen statements out of what was probably not intended to be broadcast in the first cabinet meeting that it's the international community, meaning U.S., Japan, EU's responsibility to enforce this ruling, but the Philippines might not actually say anything itself. I don't think that that's realistic. I don't think anybody in Manila really thinks that's realistic. This is too much a cause célèbre in the Philippines. Any attempt to hide from this one will get the administration lambasted in the press and in the public, and I don't think that was really what was meant by the incoming government anyway. Obviously, they want to change the rhetoric with Beijing, and there's been a lot of talk about pursuing joint development. Scarborough Shoal was mentioned. The court just opened a great door for joint development at Scarborough, or at least fishing cooperation at Scarborough Shoal, by saying that both countries have a right to artisanal fishing or traditional fishing. Reed Bank's also been mentioned. Like I said in my remarks earlier, Reed Bank is kind of closed on this one, or at least it'll be very difficult for any Philippine administration to offer joint development in the sense that China wants, which means as two sovereign states sharing resources, they'll have to go back to the Aquino administration's policy of, if, say, CNOOC wants to engage in development of Reed Bank, they must do so under Philippine domestic law and sign a PSA with the Philippines, presumably. But the bottom line is, no matter what the Duterte administration wants, this ruling, I think, effectively sets the boundaries of what will be politically acceptable in Manila. The court has now very clearly, very crisply said what is and is not disputed. Any attempt by any future Philippine government to go out and say, well, let's talk about joint development of areas that the court just said are ours exclusively, thus the meaning of the EEZ, they'll be torn apart by the Philippine press, by their public. It's just not politically doable. So, I was surprised by the Tuaba decision, not because I think that the 121.3 ruling was wrong, but because I didn't think the court would make it. It does, I think, limit the options of the Duterte government and any future government. There's a much smaller area now to talk about. So they're going to have to get very creative with whatever solutions they offer to help Beijing find an on-ramp here and step down from this. On ASEAN, we'll find out at the ASEAN ministerial meeting. Actually, we'll probably find out at the Asia-Europe meeting to some degree, but certainly ASEAN ministerial meeting later this month. I think you'll get a meeting or a statement that looks a lot like the Sunnyland statement. It may or may not mention the arbitration, but if it does, it's not going to call for anybody to respect it. It might just recognize the objective fact that it happened. In Manila, it's been made clear to me by government and others that they don't expect to get Phnom Penh and Vientiane on board with a strong statement. They'll take Sunnylands, that as long as there's no backpedaling.
Yeah, I simply want to add with respect to Ituaba, Taiping Island, that of course here, if you browse the internet, you will see that China, but then the Republic of China, has made a amicus curiae, which they submitted to the tribunal. As the position paper of China has also been taken into account, the chances are very high that the court will have looked at the content of this amicus curiae. So it means that on this point at least, the court had very good information on both sides of the issue before making the decision. Thank you.
I think I just quickly touch upon the first question about the regional kind of scenarios. Actually, if we look at the award, it's pretty quite depressing. I mean, from China's point of view. But actually, since the arbitrations started, the bilateral or even the regional with the regional states, I think things were not that bad. But I think with this award, probably really stop the new administration of Philippines ready to start to negotiate with China. We see the kind of relaxation before the award came out, but now probably this maybe make it more difficult because of a domestic or public kind of influence there. And also, I think several panels touch upon the arbitration, the tribunal, and really went out of this way to make this judgment or award decisions on the 121 issue. And I think that has been discussed for a long time. And quite a few of the international cases touch upon the issue with that. But normally they will be around the way, and or the tribunal or the court trying to get away from that and without touching on that issue. And within scholar publications, we had a lot of discussion how to amend that to specify the criteria, how to define island and the disadvantaged rocks and a category of island, things like that. But this one really, I think that's why I said a quite aggressive one. We see great progress maybe. Yeah, thank you.
All right, we're going to take 3 more questions over here in front.
Okay. As an international lawyer, I do appreciate especially the comments and explanations from 3 experts. I have 2 evaluations and 2 questions. Evaluation would be, okay, for the, especially talking about the distinction between reef and rocks, I would like to get your notice to Article 6 about the reef, because that seems to be a very new one. Introduction to the law of the sea, because like in the Spratly, most of the maritime features were based on the reef, not rock. And according to Article 17.6 of the UNCLOS, it is specifically referred to sedimentary rock. So did the tribunal actually distinguish the special characteristic of a reef and a rock instead in the words in this verdict? I read it this morning, I figured out it didn't. So that could cause some confusion as to the explanation of Article 121. Another explanation I would like be, as to Article 298, China already made declaration in 2006, and it clearly excludes those disputes. And according to my observation, there are altogether 35 countries making this regulation.
I need you to just ask a question, please.
Sure. Okay. So my question would be, what's your explanation as to, the question goes to James, what's your what's your observation as intertemporal law as to the U-shaped line? Because you mentioned about pre-existing law. Then what about the intertemporal law applied in this case? My next question will goes to Eric. What's your explanation as to ito aba, especially paragraph 6202? In this verdict, it mentioned about the absence of historical absence. But what's your observation as the criteria of the paragraph 3 of Article 121? Thank you.
All right, pass it over here to Chris Nelson, please.
Thanks so much, Chris Nelson, Nelson Report. Amazing timing. Does it still matter that China says it isn't bound by this, it isn't going to honor it, whereas people who have studied it closely, Carl Thayer last week, for example, and Peter Dutton, I don't know if Peter's here, have explained to us, citing chapters of UNCLOS, why, yeah, China has to honor this. And even if they decide to quit, it would be 1 full year before they could not honor things that had been decided. In the meantime, they are obligated to honor what's been decided. Is that still an issue now? Or is that something that there might be room for negotiation with China to try to find some way to negotiate these things? Or is China embedded in what appears to be an argument that the China bill implicitly rejects, and that is, this is our ruling, you've got to honor it. What's your sense of what happened last night and what's going to flow from that problem? Thanks.
Okay, third and last question in this round, Paul Hare. If you could bring a microphone over there, please. I think we need to get it on, because, okay, there's the microphone. Go ahead.
What options does Taipei have for responding to the decision on ito aba, and what option do you expect them to pursue?
Okay, thank you for being short. Julia, why don't you start?
I think if I look at, I didn't really read the Chinese announcement Foreign Affairs, but I think for China, like China now can be really relaxed because what China anticipated, it all happened. And before this award, and China know this is already, China call it conspiracy, and also say this is more political game and they quoted with the legal terms and things like that. I think that the world just approved that. And then if we go to, does it matter? I think it does matter. If China, to get China really to engage China with this international community, I think all the regional states, international community, including the states, I think really have to work together. And to make sure China really be willing to compromise and to adjust itself. But I think that's very challenging. And on the other hand, if China keep on going what it has been doing, as I mentioned, China very sensitive about sovereignty issue and the security issues. Looking at the history, the humiliation during the imperial period, and China really, really strong. And we can see from this administration and the leadership there, and they really show their gesture. So I think that's why I started to say I'm quite concerned. As an international legal scholar, I'm really concerned about the situation. I don't know what's going on, but I look at quickly, went through the announcement, I see whatever there. China just reiterated what it had been said for many, many times. I don't see things, but probably, Bonnie, you are right, and we will see something, action happen. And that's the thing probably we'll see how China will be honoring the award or do something to the extreme, and then also rely to the other states if they, go to the extreme scenarios, and then I think will be quite risky kind of situation for that. Sorry, I forgot the second question was from there.
I think he only had one question. Was that right, Paul? Oh, Paul's question was on Taiwan options.
Oh, yeah.
Do you want to comment on that, or do you want to pass that to someone else?
I think Taiwan is
Okay.
also, because related to Taiping Island, I think we've seen quite a lot of actions in recent years by the former President Ma Ying-jeou. And that's, I think they show very, very strong gesture about the legal status for Taiping. And also you can see very clear kind of historical evolution about the sovereignty within the U-shaped line or in the South China Sea by both the position paper issued in December 2014 and also the March this year by the Chinese Taipei there. And you can see their positions, they share actually exactly the same historical evidence there and the records they claimed. So I think that's another issue. I don't know what they will be responding to that.
Greg, you want to add to that on Taiping?
Sure. I mean, we've already seen a statement this morning out of Taipei that I actually think was out quicker than the MFA statement in Beijing, to the effect that the ruling is a violation of Taiwan's sovereign rights. That said, I mean, it is damaging. It is clearly morally damaging. Taipei sells itself as the one that always follows customary international law, even though it's not a party to the convention or a member of the UN. It will, I think, for the time being, hide behind the fact that the ruling is technically only binding on the two countries, but the precedent is as damaging to Taipei as it would be to the US or Japan or others.
Okay, James, on intertemporal law.
Sure. Thank you very much for the question. With regard to that, I just refer to my comments on the decision. So just look at the podcast and rewind what we talk about as far as the law of the Sea Convention extinguishing prior rights.
Eric, 121.3.
I would like to take on another question, can I? And that is about, the issue raised, what is the implementation of the agreement, and if China gets out of its commitments towards the 1982 convention. The impression I had from the question that apparently it is thought and that the decision then will become null and void with respect to China. Of course, this is not the case. You can get out of the treaty obligations, but whatever was done during your treaty obligations will remain, from an international law point of view, applicable.
Okay, I think that's an important addition. All right, we're going to take 3 more questions. So this woman, you in the back, right there, if there is a microphone somewhere in the vicinity, thank you very much.
Thank you. Amanda Macias, Business Insider. Since the 9-dash line has been declared invalid, I was wondering how likely is it that other nations with claims in the South China Sea are willing to push China and what that might look like?
Okay, that's an interesting question, especially whether any other countries might be interested in filing their own case with the tribunal. We'll go to the gentleman over here with the green tie and the blue suit. There's a microphone coming up behind you.
Hi, my name is Do Thanh Hải from the Diplomatic Academy of Vietnam. I would like the panelists to assess the possibility, because the award ensured the traditional fishing rights in some areas. So whether any ramifications or consequences impact of that award on, maybe Vietnam traditional fishing rights, the paracels, and also how about the delimitation negotiation among the countries in the regions. From how to assess the impacts on that and whether the country can apply it into the negotiation. Yeah, thank you.
Okay, and if you'll pass that across the table, the woman across from you will be our 3rd question. Thank you.
Charmaine de Gracias, visiting fellow from the Philippines East-West Center. On the aggravation of dispute part of the ruling, when the tribunal ruled that it lacked jurisdiction on military activities, such as the standoff between the Philippine Marines and Chinese law enforcement authorities, I'd like to know what will happen here on. If the China will continue to patrol the area, it will choke off effectively supply routes of the Philippine military to its outpost. What do you think will happen next? Will that even embolden China?
Would you like to begin?
I think all these questions, they are more or less kind of trying to anticipate what will be the consequences of this award. I think it's too early and too difficult for me to predict. But I think we do have to worry about that and look at if this award is helpful to diffuse of the regional dispute here, or it's really getting more complicated, going deteriorated. and also relate to a lot of spillover effect, and we are yet too early to assess that. So I think there is, with the specific situation, as you mentioned, I reckon according to China's position or state practice, I think China will going to do whatever it has been doing. And then the other state, when you have the ruling in hand, you will probably intervene with China, and then we can imagine kind of escalation of tension at sea. And the situation probably in extreme cases, it might get out of control and things like that. So I think with the Spratly Island area, the water there are going to be tricky. And for the Chinese government, whatever it's going to do, I mean, for the at-sea enforcement, won't be the same from the view of the other states. And even for the fishermen, they do go fishing, and there will be EEZ and Philippines. And things will not be the same as previously China regarded as disputed area or things like that. So I think we will see the overall kind of situation, and we remain to see what kind of will turn out. I mean, will lay out the regional views for the future.
Thank you very much. Also, if I could just revisit, the gentleman on my right had a question about does it matter, and I just would say that one thing to think about is the endurance of the Nicaragua decision in the International Court of Justice, where the United States did not withdrew its consent, but the court went ahead anyway. The impact of that has been really all-encompassing in the field of the law of armed conflict to this day. And so even if the principal party doesn't observe or comply with the decision, but nonetheless the rule persists and becomes accepted as part of international law and is very influential. And so I would suggest that that's what will happen in this case. Concerning the question on the 9-dash line, because it's invalid, will it encourage other states? I think so, and I hope so, in that lawyers are paid to predict the future, and this is fairly easy money, it would seem, to pursue. The question about traditional fishing rights in the Paracel Islands are not directly implicated, other than that states have historic rights to resources under Article 62, in which the country that has those rights may approach and discuss or engage with the state in whose waters they seek to fish. And so that is the recourse that I would encourage China to do with regard to the Paracel Islands vis-a-vis Vietnam. And then finally, the issue the woman asked about Second Thomas Shoal and military activities. While the tribunal appropriately did not discuss military activities, but nonetheless, it did discuss public vessels, including law enforcement vessels, as violating both flag state responsibilities under the law of the sea conventions, Article 92 and 94, as well as Rules 6, 7, and 8 of the collision regulations for crossing in front of Philippine vessels and interference with navigation and disrupting the Philippines' rights in its own EEZ. So from that perspective, it did approach applying some of the rule of law with regard to these gray zone situations in the maritime militia.
Yes, of course. You're next.
Thank you. With respect to the 9-dash line, I would simply like to add that this is a very peculiar situation, because this is a claim that has been shelved without China ever having been able to clarify what the exact content of the claim was all about. Russia has done quite a similar thing with respect to in the Arctic, where they have these sector lines. They have never explained what they exactly were and always have been able to take some profit out of that. I think China now has no longer that advantage, because now you have a decision that the line by itself is not founded based on international law. With respect to historic fishing rights, I think, yes, I would go a little bit further with respect to the paracels. If you apply the same reasoning of the court, you first have to see what kind of features there are. If there are not islands, it's 12 nautical miles, and if it's 12 nautical miles, yes, you have historic fishing rights in the area. So I would say a little bit more optimistically that probably also the same applies or will apply with respect to the paracels, of course, under the condition that all the islands are 121 paragraph 3 rocks. And then finally, with respect to the military standoff, I would simply like to add, yes, the tribunal has done a great job not to touch upon this because China explicitly excluded it. But this does not mean that this issue is then up into the air. No, it means that the both parties still are party of the United Nations Charter, which means that, of course, you have to settle all your disputes in a peaceful manner. So it means the obligation is still there. It's only not for this tribunal to make a point out of that.
Very good point. Greg, anything you want to add?
Yeah, on the first question, we've seen two Southeast Asian states already publicly express some degree of interest in arbitration, Vietnam and Indonesia, at various points. This opens up a whole host of options to both. As Eric said, there's the questions now of what's a rock and what's an island in the paracels. There's now the possibility, I suppose, of challenging the straight baselines around the paracels, given that they would seem to meet the same definition as the Spratlys of an island group that should not be able to make joint maritime claims. For Indonesia, if the continued fishing in historic waters continues off the Natunas, obviously that's in violation of the letter of this law. I don't know if either can, but it's a very useful bit of leverage to have. And just real quick on the second Thomas Shoal, the court did say that it did not have jurisdiction to rule because of the 298 exclusion. However, it did also say that second Thomas Shoal is an undisputed part of the Philippine continental shelf as a submerged feature outside the territorial sea of anything else, which means that the next time there is a blockade, if there is another blockade, even the pretension that China would have had of this being a contested feature is removed. It heightens the pressure on the U.S. under the MDT, because now not only are you facing an Article 5 obligation to a Philippine public vessel and troops in the Western Pacific, you're facing it in undisputed Philippine waters. So how you can walk away from that with a straight face to Manila, I can't imagine.
Also a very good point. Okay, we have another few minutes, and I'm going to take one last round of questions. The woman up here in black, you had your hand up earlier. If we can...
Hello, I'm Angeli Marazan from Manila Mail newspaper. I have a question for Ms. Julie. You said earlier that it is too early to predict the consequences after this ruling. May I ask you, what is your gut feeling? What would you suggest China should do?
Please wait. I'm going to see if there are any more final questions to add to the queue. Yes, this gentleman right here, and then we have one in the back, and then we'll come back to the panel.
Hello. JiaBin Huang from George Mason University. I'll try to address my question to Professor Julia Su. What do you think the impact, the postponed impact of the arbitration decisions on the COD, positive or negative?
Okay, and back there, please. Okay, there's a microphone on its way. Just wait 1 second.
Ken Meyergord, World Docs. There's a reef in the Hawaiian Islands chain which we claim a 200-mile EEZ around, even though it's submerged, even at low tide. The other gentleman mentioned a couple of other islets that we claim EEZs around that would probably be classified as rocks under the conventional law of the sea. Do you think this is the primary reason that we refuse to sign the convention?
First, I should say that the U.S. signed the convention but has not ratified it, and there is a distinction.
I'm not a lawyer.
I'll let somebody answer your question in a minute. We'll start with you, Julia.
Yeah, about suggestions. I think as an international law scholar, I should stand with international law, right? But I'm the Chinese national. And I know probably better, than non-Chinese national about the governmental positions. And I worked hard, I dig really hard to see if there are any kind of incidences for a government to, because there is argument, say, when China signed up the UNCLOS, China should roll back its claims to line up with UNCLOS. And I look at the cases, if there are anyone to roll back to give up its sovereignty, I haven't found one. And there is only one case for they give up the adjustment, rollback of the claim to line up with UNCLOS. That's the Rocco Island, the rock by UK. And when they send up the UNCLOS and adjust this fisheries zone up to 200 nautical miles back to, according to the rock status. And because this is sovereignty and within the U-shaped line for so many years, really time-honored. So I don't really think about if China will give up those rocks. Now it's all rocks, and China really regard them, some of them as island, not all rocks, or even low tide elevation. So I think this is probably too hard for me to predict. And about a possible impact on COC, you mentioned, right? I think there's ongoing negotiation among the China and ASEAN states about the COC, and the award touch upon the DOC and really disregard about the legal kind of nature. But that's the way area actually I don't really agree, because if you diplomats here, you understand when you negotiate even just agreement, a political agreement, announcement, declaration, a proclamation, and you know how much effort you put into it, right? It's similar kind of function, and as the signed one, the legal treaties. So I think this is somewhere I really don't agree with that. And then I myself had participated so many of the occasions, and I see the effort between China and the ASEAN state. They put together, really want to work out something. But I think this is something probably for the states involved, they need to renegotiate or readjust themselves. I don't know what's going to be, the future kind of gesture. It's certainly desirable for China really to take this opportunity and to negotiate with regional states and adjust its position. And then I think for the both parties to work out something workable or even meet in the middle. And then probably there will be really a beneficial to all the region or to the international communities.
Thank you, sir, for the question in the back. It's absolutely not the reason that the United States has not signed UNCLOS. You can refer to the March 10, 1983 Statement on Oceans Policy by President Reagan, in which President Reagan said that the reason why the United States would not sign the treaty is because of problems with Part 11 on seabed mining, and that, in fact, the United States accepted all of the other portions of the treaty as reflective of customary international law and therefore binding on all states. And so it's really the Part 11 on seabed mining which was at issue. The irony, of course, being that after the seabed mining Part 11 was revised in the early 1990s with the Clinton administration, President Clinton signed Part 11 on seabed mining, but we actually have never signed the Law of the Sea Convention itself. So that's the reason why.
Greg, any final thoughts?
Yeah, I would just add, from the U.S. perspective, not only do we act as if the treaty's in effect, the vast majority of the questions we're discussing here are matters of customary international law, according to the ICJ, among others. So the status of an island as an island or a rock is not really a matter of UNCLOS. It applies whether you've ratified or not. What the U.S. does is it gives up all the privileges of UNCLOS and still bears most of the responsibilities. We can't, sit in the ISA. We have no access to the CLCS to submit an extended continental shelf claim in the Arctic, and yet we have all of the same responsibilities in an EEZ or a guardian island or a rock as anybody else would.
Clarify, we signed the treaty or not signed the treaty? That's two separate things. Maybe that has to be.
Oh, we signed it, but we didn't.
No, we didn't sign the treaty. We signed the 1994 implementing agreement that is read as part of the treaty. The irony, of course, being that that's the part that the people who reject the treaty have a problem with.
All right, I stand corrected. We signed something, but I know we have not ratified the treaty, and it is, there has recently actually been a resolution that has been forwarded, a bipartisan resolution in Congress to have the treaty ratified. So this is still something that is under discussion. For the time being, though, we are going to end this really terrific panel, which I think has given us a very good introduction. So please join me in thanking the panelists. We're going to take a 15-minute break, and then we will have our next panel. Over lunch, we will have Dan Crittenbrink from the National Security Council and many more interesting panels.